May it please your lordship.
Yes.
Lordship, I beg to mention a criminal petition which was filed yesterday, my lord. My lord, may it be listed on Friday. It pertains to rejection of a 313 application by the learned trial court, my lord.
Okay.
Deeply obliged, my lord.
May I please? Well, I'm mentioning for listing of a criminal petition which was filed on yesterday for quashing on Friday, my lord. Some urgency will oblige.
My pleasure, Lordship. Sir, I beg to mention item number 6, Lordship.
6.
Yes, Lordship. Kindly pass over the matter for detail, Lordship. I have obtained the consent of the other side also.
Okay, on the prayer of Ms. P. Chohria, learned counsel for the petitioner. The case is passed for the day. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer.
Obliged.
May I please, Lord? Also, I'm praying for listing of a case for orders.
After the application. Many orders have been passed for listing. Huh? Give it to the court master, he'll fix it.
May I please, Lordship? I beg to mention item number 2, Lordship.
Item number 2.
Okay.
Yes.
Agenda matter for the day, Lordship.
Okay. On the prayer of Miss
P. Kolita, Lordship.
Nicolita. Okay, same. PP likhi dibo.
Obliged.
May I please, Lordship? I beg to mention item number 18, Lordship. Pass over for the day, Lordship.
18.
Yes, Lordship.
Okay, you are Mr.
Yes, Lord.
A. Islam. Pass forward for the day, huh? PP.
After vacation, Lordship. Oblige.
After vacation.
After vacation.
Okay. Did you?
Lordship, I beg to mention item number 23, Lordship. Kindly agenda matter for the day, Lordship. Item 23.
You are for the?
I'm for the respondent number 2, Lordship.
I'm for the petitioner, Lordship.
Okay. Mr.
Y. Kothari.
Y. Kothari, learned counsel for the petitioners is present. Miss
PP Dash, Lordship.
P.V. Das, learned counsel for the respondent number 2. And Mr. MP Goswami, learned additional public prosecutor for the respondent number 1. State of Assam is present. P. Das has made a prayer for adjournment.
After vacation, Lordship.
Post up. As agreed to by the learned counsel for the parties, lays the case on so and so.
Lord. Deeply.
Obliged.
Deeply.
May I please, your lordship? Lordship, I beg to mention for listing a Jimma matter, lordship. It was last posted on 21/11/2025. Can it be on Friday, lordship?
No, not Friday. After vacation, immediately after vacation.
Lordship.
Any report is required? Oh, no. Give it to the case number to Mr. Goswami. Oh,
May it please, your lordship, I beg to mention item number 19, lordship. Kindly pass over for the day.
19. Okay. Miss,
Pass over for the day.
your name?
lordship. Need after vacation, lordship.
Your name?
A. Mohanta.
Okay. On the prayer of A. Mohanto, learned counsel for the petitioner, lays the case on so and so. Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, State of Assam is present.
Mass of blessed.
May please, your lordship. I beg to mention item number 9. Today speaks for CD, but CD is not received, lordship.
CD?
CD is not received, lordship. Yes, that is not received.
9. Key 9 to some?
9.
TD call for quashing of FIR.
Quashing of FIR.
Yes.
CD call for?
Lordship.
Okay. Mr.
A. Huda.
A.
A. Huda.
Buddha, learned counsel for the petitioner is present. Petitioners. Hello, petitioners of the petitions. Mr. MP Goswami, learned additional public prosecutor for the respondent state has submitted that he has not yet received a copy of the case diary, consent case diary poster as sought for by Mr. Goswami. Lays the case on
After 2 weeks.
28 one.
28.
That may be fixed, lordship.
28.
Hello, blessed.
For motion. Item number 1.
May I please, your lordship? Lordship, in this case, lordship, petitioner before lordship, she is a victim of a POCSO case, lordship, where lordship, the trial is presently undergoing at Nagaon, lordship, before the court of the learned special judge POCSO at Nagaon. Now, what has happened in this case? Initially, case was registered under provisions of POCSO Act and IPC. Thereafter, lordship, what has happened after on completion of investigation, charge sheet was submitted, but only a single accused was shown as an accused person, Whereas in the FIR and the 164 statement, the victim, the present petitioner, had named around 10 other accused persons. So what the investigating officer did, the investigating officer filed the charge sheet by omitting the names of the other accused persons from the charge sheet. They are not sent up. We filed a petition before the learned trial court stating that these other accused persons are also involved in the case and which are discernible from the FIR as well as the 164 statement. Our petition was rejected before the learned trial court, stating that there is a provision under the earlier CRPC under section 319. So section 319 can be resorted to by the court even after completion of the prosecution witnesses. So thereafter we approached this honorable court by filing a criminal revision. That revision was allowed, and the learned trial court was directed to decide on the matter afresh. They later approached the Supreme Court. Supreme Court also rejected their petition. Now, after that, we went before the trial court issued notices to all the accused person. They are facing trial. Now, all the accused person from accused number 2 to 10 other accused person, private respondent number 2 to 11 are facing trial. Now, what has happened, Lordship? We are aggrieved by the prosecution witnesses. These are all the prosecution witnesses who are vested interested and are interested and are related to all the accused persons. So we filed a petition stating that some of the witnesses are to be expunged from the witnesses mentioned in the charge sheet. We have specifically mentioned that. May I read the petition, Lordship? Page 65, Annexure 9. May I read, Lordship? Most respectfully, the applicant begs to submit that she is the informant of the case, and during the course of trial, the prosecution has already examined 4 witnesses, including victim, informant, applicant herself, and the MO, whereby the prosecution side has fairly been able to establish its case to a large extent. That during the investigation, the IO of the case being gained over by the accused side acted partially in conducting the investigation, for which the victim, informant, applicant filed complaints against the IO before the DSP headquarters Nagaon as well as the State Police Accountability Commissioner Guwahati. Thereafter, monitoring application was preferred before Your Honor, whereupon Your Honor was pleased to call for the progress report, upon which the IO, with an intention to meet up his grudge and with a view to destroy the prosecution case, projected some witnesses who happened to be near relatives of the accused person of the case and also prayed before the Honorable Court to record their statements under 164 of the CRPC. Those witnesses, being near relatives, manufactured a different story and projected the same according to secure the accused person from conviction from the heinous crime they committed. That for this misdeed, the victim, informant, applicant again complained against the IO before the Accountability Commissioner, whereupon spec case number so and so was instituted. For that, the IO of the case upon that grounds submitted the charge sheet against the arrested accused person only by showing the remaining accused that not sent up for trial, in spite of the fact that there were sufficient materials against them. The above acts of the IO of the case clearly transpired the ill and illegal intention of the IO to demolish the prosecution case in the behest of the accused. That the victim, informant, applicant wants to submit that the below named witnesses may significantly hinder the prosecution case. So the victim, informant, applicant hereby urges the Honorable Court not to examine the below named witnesses, as the prosecution do not want to produce them. The names of the below named witnesses and reasons for the non-examination are well mentioned below. Witness number 1, so and so, as the girlfriend of accused number 4. Later on, she got married with him. Number 2, name so and so, serial number 8 of the charge sheet. She is the wife of accused number 1, Dipankar Das. During the investigation, she was his girlfriend and she introduced herself as his cousin in the affidavit filed with his bail petition in the Honorable High Court. Number 3 and 10 are the maternal uncles-in-law of accused number 1, Dipankar Das. Number 4 is the near relative of accused person. Number 5, serial number 12 of the charge sheet, is a close friend of accused, namely Pompi Hazarika Das. Number 6 is already gained over by the accused person, Upen Mohanto. 7 would not be relevant. Evidence of Mohendra Sharma and Benu Kumari Devi are not necessary in this case. Other official witnesses may kindly be called and examined. That the accused persons are presently exerting tremendous pressure upon the victim, informant, applicant by adopting different tactics to give up the case. The accused person have engaged their near relatives to compel the victim informant applicant to succumb to their illegal pressure, for which the victim informant applicant was bound to lodge an FIR upon the near relatives of the accused person of the marginally noted case on 4/11/2024, which was registered as Nagaon case number so and so. That the instant case is old one and is pending trial for the last 8 years. So for the ends of justice, it requires expedite disposal and production of the above noted immaterial witnesses who are relatives to the accused person and introduced in the charge sheet in collusion with the IO by abusing the process of law and projected themselves as witnesses for their own vested interest to derive benefit out of the result of this litigation, which would surely delay the proceeding for an uncertain period unnecessarily. So this petition was filed, and pursuant to this petition, the impugned order has been passed, which is at page 69. And
Yes, I have read the order.
Yes.
What is wrong with it?
No, Lordship, the only stand taken by the learned trial judge is that the witnesses which the prosecution relies on, that is the discretion of the prosecution. So our
Where is the law for that
that
to
is-
expunge the
that is-
witnesses, to limit the witnesses?
is the difficulty. Otherwise,
Yes.
from the very beginning, the
If
investigation.
the law is also that if the prosecution does not call
Yes.
these witnesses, then defense has every right
To
to
prosecute.
call the witnesses for their defense. Right? That will demolish more
That obviously.
the case of the prosecution
Yes.
that intentionally did not call up,
Yes.
and because of this. For free and fair trial, yes, you can demolish there by cross-examination.
Cross-examination.
Because the petitioner is a victim, Lordship. That way also, Lordship.
Where is the show me anything that you can,
That is,
if that is so, then again, the private lawyer will have every right that to direct the public prosecutor, call these 20 witnesses, these 50 witnesses.
otherwise also section 311 is there, Lordship.
311 is there, but law is also there that if the prosecution does not call any of the listed witnesses, they have every right to call them as defense witnesses.
The difficulty now is that is not that the
Other way.
prosecution will not call, it's the other way around.
Other.
If they call, Lordship, these witnesses, this will hamper the case of the victim. That is why the victim is apprehensive about the entire trial.
Right, but for free and fair trial,
Of course, he has a recourse to the earlier section 311 by which
and you can
Even-
assist
Yes,
under
that-
section 301 CRPC now, I don't know what is the provision,
is-
BNSS.
And if.
Your
Malad-
private lawyer can assist the special
yes.
public prosecutor,
very true, Lord.
Yes, it is done.
right?
And also, Malad, if there is any doubt with the Malad investigation, so at least he should file an application for any further investigation if they don't rely on the witnesses, Malad. If there is any, because otherwise, Malad, they will get the chance to cross-examine and demolish the witnesses. So perhaps this petition is not liable.
Otherwise also, from the
Maintainable
very
manner.
beginning, the investigating officer has acted with malice in this
So
case.
you have approached this Police Accountability Commission, that is all right.
Yes.
Not
But
only,
so
not
far as limiting the
only that, Lordship, had it not,
any authority on that, because I have not come across.
Lordship, very true, Lordship. Otherwise, there
So
is. also-
you can highlight, you can enlighten us,
No. There is a
and
program.
definitely we will take note of it.
Under section 311 in the old CRPC also, even if witnesses who are not cited in the charge sheet, that.
That court has the power.
Yes.
To
court
that
will have the
extent,
power.
court has the power.
Court.
So far as what witnesses
Yes, that is the,
are to be examined,
yes,
that is within the domain of the public prosecutor.
prosecution.
Court cannot direct that don't call these witnesses, because that will hamper the prosecution case.
That possibly the petition could have been dealt in a proper way.
No, what
The-
more? Because if the court does not have the power,
Lordship.
what more is required? Short and cryptic is also enough sometime.
Yes.
No, 338.
When there is no jurisdiction
Yes.
and authority,
Very well.
then he has done it in very short manner.
I leave it to you, Lordship.
If enlarging and explaining it will give rise to scope to the parties to agitate the matter more. But he is short and cryptic, but it is
The
enough.
case where miscarriage of justice is likely to be cost to the victim. That is the
But where is the
only thing, in the learned trial court gives an explanation that the petition ought to have been routed through the prosecution side.
No, it is.
The petition is not filed by the learned special PP. The court has given careful consideration. And this is a case where initially the investigating officer had omitted around 10 number of witnesses whose names were specifically mentioned in the FIR as well as in the 164 statement. So from the very inception, there is malice on the part of the investigating officer. So what he has done is that he has listed all the witnesses in the charge sheet who are interested and are relatives of the accused person.
Interested বলি
ফাইল করবো লাইক
একটু ইন্ডাস্ট্রিয়াল ইনভেস্টিগেশন করবো তাই জানি
You have any private lawyer? You have engaged
private lawyer,
to assist the public prosecutor
that instruction. Lordship,
under section 301, subsection 2.
That instruction, Lordship.
now my lord 338(2) subsection 2.
Now 338(2).
Right.
The impugned order shows that learned counsel, one of the learned counsel has appeared. And whether leave was taken or not, that
Application from ladies.
The public prosecutor assists the prosecutor in charge of the case and conduct the prosecution. We do not find any infirmity so far as the order is concerned.
Lordship,
No.
I understand.
Where are their 161 statements?
Lordship,
The
161
161 statements, previous statements?
statements are not here, but.
I have notice not issued, my lord. Notice not and TCR not called for.
Because the order itself is not
Not
incorrect. There
not
is no
incorrect.
impropriety
No,
to look further into the matter.
lords.
I understand.
We'll close this. Heard Mr. A. Ganguly, learned counsel for the petitioner. And
Can
Mr.
we, for a direction, Lordship, that this case has been going on for the last 10 years. Can there be a direction to that effect that within a time frame that?
Have you seen the recent judgment? Don't direct the
Don't
trial
direct.
court. High court, don't direct.
Because this petitioner
Or
is under a lot of anxiety, Lordship, due to this.
see the recent last 2 weeks observations by the Supreme Court.
I will look into.
Don't direct. Respond number 1, comma, State of Assam. Full stop. Para. The present criminal revision petition under section 438, read with section 442 of the Bharatiya Nagorik Suraksha Sanhita 2023 is directed against an order dated 22/04/2025 passed in petition number 173/2025 by the Court of Additional Sessions Judge cum Special Judge within bracket POXO, Nagaon, Assam, page 69. In the course of proceedings of Special POXO case number 48 within bracket capital N bracket close stroke 2018. Full stop. Para. The case of the petitioner, sends the unnecessary details, is, in brief, that the petitioner as an informant lodged a first information report before the officer in charge, Hodor Police Station, Nagaon, on 16/8/2017, alleging inter alia that the accused number 1, 2, and 3 on 15/8/2017 had gang raped her. Also, in the FIR, the petitioner, that's informant, stated her age to be 16 years and had named 12 persons as accused. Post op. On receipt of the FIR, the same was registered as Nagaon Police Station case number 2212/2017 for the offences under section 143, stroke 341, stroke 342, stroke 328, Indian Penal Code IPC, RW section 6, Protection of Children from Sexual Offences Act 2012 POXO on 6/8/2017 itself, and entrusted the investigation to a sub-inspector of police attached to the said police station. Full stop. After completing investigation, the IO of the case submitted a charge sheet by charge sheet number 699 on 31/5/2018, finding a forensic case established against the accused number,
Respondent number 2, Lordship.
accused number 1, that's respondent number 2, under section 4, POXO Act. Full stop. Other than the accused number 1, that's respond number 2, the IO did not send the other accused persons named in the FIR to face the trial on the ground that sufficient materials could not be found against them. To forward the case for trial. Full stop. In the FIR, the IO listed 15 number of witnesses who deposed to establish the case of the prosecution in the trial. Full stop. Para. On receipt of the charge sheet, the special court registered the same as special POCSO case number 48 within bracket N stroke 2018. And after taking cognizance, issued process to the accused number 1, that's respond number 2 for his appearance before the court to face the trial. Full stop. Para. Agree by the fact that the other accused persons named in the FIR were not charge-sheeted, the petitioner, that's informant, as the victim, took recourse of law by initiating proceedings in the form of petition number 1761/2018 before the special court, followed by criminal revision petition number 138/2019 before this court. Full stop. By judgment and order dated 16/9/2022. This court disposed of the criminal revision petition by setting aside an order dated 26/2019 passed by the special court. Full stop. By the order dated 26/2019, the special court had observed that even if the other accused persons, namely the affair, were not charge-sheeted, the court had power under section 319, Code of Criminal Procedure CF 1973 CRPC to bring any other accused not named in the charge sheet, if sufficient. If there appeared evidence against them regarding their involvement in the offenses for the charges under trial, offenses to charges under trial, full stop. While setting aside the order dated 26/2/2019, comma, this court remanded the matter back to a special court to consider the matter afresh after affording an opportunity of being heard to both the parties and to pass an order on the charge sheet submitted under section 173 within bracket 2 CRPC. Full stop. Agreed by the judgment and order dated 16/9/2000, said judgment and order dated 16/9/2022, comma. The petitioner, the respondent number 2211 approach the Honorable Supreme Court by way of a special leave to appeal, comma, special leave to appeal within bracket CRL number 11480/2022. Full stop. But, comma, the Honorable Supreme Court dismissed the special leave petition, comma, by an order dated 12/10/2022, comma, by declining to interfere with the judgment and order dated 16/9/2022, passed by this court. Full stop. Honorable Supreme Court observed that the trial court shall decide the case on its own merits without being influenced by any observations made in the judgment and order dated 16/9/2022. Full stop. Thereafter, the trial court considered the matter afresh. The special court considered the matter afresh and by an order dated 14/2/2023, 4/2/2023,
Page 59 is the operative.
in its order dated sense, the special court observed that there were sufficient materials to issue process against the respondent number 3, 4, 5, 6, 7, 8, 9, 10 and 11. So 3 to 11. Post hoc. To stand in the trial. Post hoc. Accordingly, the special court issued process against the newly implemented accused persons for their appearance before the special court. Post hoc. Thereafter, on (21/6/2023), the special court framed charges under Section 6, POCSO Act and Section 366 IPC against the respondent number 2, semicolon. A charge A charge under Section 6 POCSO Act was framed. Oh, sorry, 2 and 3. 2 and 3, 2 and 3.
But Para 9 of my petition, I have stated everything in one. What are the charges framed against which of the respondent?
Para 9.
Para 9.
The special court framed charges no, I do. 2 and 3. Post hoc. Yeah, against the other accused persons, charges under Section 6 and stroke or Section 8 and stroke or Section 17 of the POCSO Act was stroke were framed. Post hoc. Thereafter, the trial proceeded to the stage of evidence. Post hoc. Para. When 4 witnesses from the prosecution side were examined, the petitioner as informant, as victim, submitted a petition before the special court. With a prayer to the special court not to call number of witnesses who were listed as witnesses for the prosecution in the charge sheet dated 31/5/2018. Post hoc. The reasons for which those witnesses were not to be called by prosecution were mentioned in the petition, full stop. The same petition was registered and numbered as petition number 173/2025. Full stop. Para. The learned counsel for the parties were heard on petition number 173/2025. Full stop. The special court noted that the petition was not filed by the special public prosecutor. A POCSO concern, who was conducting the prosecution on behalf of the state and who was in charge of the case. Full stop. It is pertinent to note that as per subsection 1 of section 32 of the POCSO Act, it is a special public prosecutor who is to conduct cases under the provisions of the POCSO Act before the designated special court. Full stop. It is a special court, right? POCSO
Yes.
court.
Yes. Special.
In the impugn order dated 22/4/2025, the special court has observed that the prosecution is to run by the special public prosecutor, and it is his prerogative to produce or not to produce any of the witnesses cited in the charge sheet to bring home the charges framed against the accused persons. Full stop. The special court has further observed that it cannot pass any order directing the special public prosecutor in any manner regarding production of the witnesses. Full stop. Observing so, the special court by the impugn order dated 22/4/2025. Dismissed petition number 173/2025. Full stop. From the provisions of Section 32 of the POCSO Act and Section 338 of the Bharatiya Nagorik Surakha Sanhita 2023 within bracket earlier, Section 301 CRPC. It is evident that it is a special public prosecutor who can only conduct the case for the prosecution for the offences under the POCSO Act before a designated court. Full stop. It is within the domain of the special public prosecutor to call the witnesses either from the list of witnesses cited in the charge sheet or any other witnesses whom he finds relevant for the purpose of the prosecution case, subject to the permission of the court wherever necessary. Full stop. The special court, a court does not exercise any power to give direction to a public prosecutor defined under Section 2 M, small m, public prosecutor defined under 2 within bracket V, BNSS, within bracket, earlier 2U, CRPC. Or for that matter, a special public prosecutor, defined under section 2M of the POCSO Act, not to call any witnesses from the list of witnesses cited in the charge sheet. Full stop. In such view of the matter, the this court does not find any incorrectness, legality or impropriety in the impugned order dated 22/4/2025. Full stop. Where? Full stop. Consequently, this criminal revision petition is found to be bereft of any merit. The same is accordingly dismissed.
Cannot read.
Can copy. Received, not received. But vehicle custody.
Yes, my lord. And also documents are.
Let us see the office note. Oh, today is the second date. Maybe because of vacation. Okay. Mr.
MS Ali, my lord.
MS
MS Ali.
Ali, learned counsel for the petition, and Mr. MP Goswami, learned additional public prosecutor for the respondent state, are present. Full stop. The scanned copies of the TCR and the case diary are not received. Full stop. Release the matter on so and so. Issue a reminder. Release the matter on so and so.
30/01.
Okay.
Item 4.
No, my is crossing.
Interlocutory application was to be filed. The learned counsel for the petitioner is found absent to the on call. Mr. MP Goswami, learned additional public prosecutor for the respondent of the state, is present. Full stop. No interlocutory application for implement of the informant has been filed by the petitioner in reference to the order dated 9/12/2025. Full stop. In view of non-representation on behalf of the petitioner today, let the case for justice be listed again on March or January, February.
That's 4th February. 4/2. Item 5 for admission.
Yes, what is the matter about?
May I please?
Filed yesterday only.
Oh,
Let it come before.
objection filed. Affidavit. Okay.
Lordship,
You have received copy.
I received the call.
Then
Uh,
Dr. N. Borua. Dr. N. Borua. You are Dr. N.
yes,
Borua.
yes.
Learned counsel for the petitioner, Mr.
April.
A. Bora. learned counsel for the respondent are present. Full stop. Mr. Bora has submitted that an affidavit in opposition on behalf of the respondent has been filed recently by serving a copy to the learned counsel for the petitioner. Full stop. Para. As I said, affidavit in opposition, comma, stated to have been filed on behalf of the respondent, comma, is not on record, comma, the office to trace out the same and list the case on so and so, along with the said affidavit in opposition.
4th February. 4th.
30th.
No, these are very few working days.
Lordship, the
We have hardly few working days this month.
30th Lordship, kindly Lordship.
February.
February then 10th by 11. 10 video.
11. 10.
Obliged, obliged.
11 to.
11.
Lordship, I'm sorry, Lordship, item number 4, I wasn't at the court, Lordship. Do not come on time. Date has been fixed in the month of February, Lordship. Can it be?
No, that in the one city, no date in January. We have hardly 7 days, or 7 or 8 working days.
First
January, so only February.
week of February.
Okay, SP Chaudhary लिख लो. SP Chaudhary, item number 4. I recorded your absence.
Yes, Lordship.
You did not file any implement application also.
Exactly. So the thing is that implement application otherwise not required in this case because then
We
challenging.
don't know.
Yes.
We don't
already
know
I have
that.
mainly mentioned.
You made the submission.
Exactly,
Your
Lordship.
submission was recorded.
Yes, I made
I will
it.
not deliver it further.
Exactly, Lordship.
Item number 7.
You non-representation लिखित नहीं लिखो. But interlocutory application only लिखो.
Item 7.
You are for the respondent. You were supposed to file objection. Where is the petitioner? There is no representation on behalf of the petitioner today on call. First up, Mr. MP Goswami, and additional public prosecutor for the respondent number 1, State of Assam, and Ms. C. Borua. S. G. Borua, learned counsel for the respondent number 2 are present. First up, in view of non-representation on behalf of the petitioner, learned counsel for the petitioner. Today on call, let the case for ends of justice be listed again on February.
6 February. 6 to.
Obliged, my lord.
Item 8.
May it please your lordship. Your lordship, as per the office note, the TCR that was called for has not been received. So another notice may be issued and the date may be fixed after Bihu vacation.
Implied notice has been issued. Probably. Mr.
A. Mishra on behalf of S. Nawaz.
A. Mishra for the petitioner and B. Sharma, learned additional public prosecutor for the respondent state are present. Full stop. The scanned copy is of the TCR, comma, as called for, comma, are not received. Full stop. Issue a reminder. List the case to on
6 February, sir.
Obliged, your lordship.
Item 10 for orders.
May I?
Number 2, I have filed a activity in opposition, but I have seen it is not take much. I have filed on the 4/11.
What is the application about?
May I please your Lordship, Lordship, the senior is in DRT, actually, kindly.
Anyway, his affidavit or objection is not on record. Miss
D dash.
D. Das, learned counsel for the applicant.
Kindly fix it at 2, your Lordship.
No, we cannot proceed.
Along with that.
Oh.
Mr. B. Sharma, learned additional public prosecutor for the opposite party number 1, State of Assam, and Mr. N. Uddin, learned counsel for the opposite party number 2, Hardcore. Mr. Uddin has submitted that he has filed an objection to the application, and the said objection is not on record. Gustav. List the case on so and so date with the objection filed by the respondent opposite party number 2 on record.
6-2, 6
Six.
February.
And
Item number 11.
2. May I please?
Notice reflects neither regard as permission to take fresh steps. Notice is made returnable. Petitioner shall take steps. Yes. Issued earlier upon so and so answered. Not known. Fresh notice could not be issued. Yes.
No.
You have appeared. Okay, good.
Going to file it.
Okay. Mr. ABT Hawk, learned counsel for the petitioner, and Mr. A. Sharma, sorry, B. Sharma, learned additional public prosecutor for the respondent number 1, State of Assam are present. Mr.
AMS Mohinder.
AMS Muzumdar, learned counsel has submitted that he has entered appearance. He has instruction to appear on behalf of the respondent number 2, and he would be filing his Kalanama within a you are going to file today. He is going to file the Ukalanama on behalf of the respondent number 2 today. Full stop. Lays the case on so and so. What is the case about? Quashing.
Quashing. Father filed the quashing petition. Informant is the daughter of.
Oh, we are not hearing it today.
6-2, 6-2.
Online.
Item 12.
Raju Das.
May I
Yes.
please, Your Lordship?
What happened, Raju Das?
Service is
Okay.
awaiting, my lord.
Okay.
And,
Mr.
H.L. Oscar, my lord.
H.L. Oscar, learned counsel for the petitioner, and Mr. B. Petitioner, stay the petitioner side. Mr. B. Sharma, learned additional public prosecutor for the respondent number 1, State of Assam are present. Full stop.
I taken steps in second time, my lord.
What to do?
Lordship,
don't,
I may be allowed to take Dusty, my lord. There is urgency, my lord. My interim
Why
also
is the
not.
question of Dusty?
My interim also not considered, my lord.
Dusty in criminal cases not.
There is no interim, my lord. So it is urgent.
Maybe court has applied some mind, thereafter no
Sure.
interim has been granted. So
Lordship.
if you agree by that, you go to the Supreme Court. Right?
Lordship.
Agree by non-passing of an interim order, then you can go to the Supreme Court. Right? Because no appeal lies before the division bench.
Lordship.
This has been issued in view of the office note dated 29/12/2000. Aid for the service report in respect of the respondent number 2, full stop. As TCR has not been received, comma, issue a reminder for the scanned copies of the TCR. Place the case on students
9 February. 9.
for service report and scanned copies of the TCR.
Most tolerant.
Item number 13.
There is no representation on behalf of the petitioner today on call.
Item 13.
Notice could not be issued due to non-renewal. Mr. B. Sharman, and additional public prosecutor for the respondent state is present. Lays the case. And we have non-represented on behalf of the petitioner today on call, lays the case on so and so.
Item 14.
Fourteen.
14.
I'm appealing for response.
Respondent number,
Full response.
none appears for the petition call. Sole respondent. I interlocutor delay. Yes, delayed condonation.
Issue. Issue. Of appeal appeal, order and target. That was passed by.
Let us see what notification. কোনো কিছু কিবা আছে নেকি? Notification keeps issuing from time to time, whether that is a latest one or that has been modified. Judgment hol. Matrimonials. Maintenance or what?
Maintenance.
125.
Oh, then it is family court. Okay, heard Mr.
AK Kanu, Lordship.
A.K.
Kanu.
Kanu, Learned Counsel for the petition, Mr. M. H.
Ayub.
I.U. Chaudhary, Learned Counsel for the Mr. I.U. Chaudhary, Learned, and Mr. I.U. Chaudhary, Learned Counsel for the respondent. First of the judgment dated 16/11/2023 impugned in this criminal revision petition is passed by the Learned Principal Judge, Family Court, Kachar at Silchar in FC within bracket CRL case number 1 of 2019, page 7. Full stop. The Learned Counsel for the parties have referred to notification number 30, dated 21/3/2023 and dated 22/05/2024 to submit that matters arising from orders and judgments of the family courts are to be listed before the Honorable Special Division Bench. Post of the registry to look into the matter and thereafter list this case before the appropriate bench. After a week. Number here, silo.
Lordship, sorry for interruption, Lordship. In item number 7, there is some urgency, Lordship.
My senior is in mediation, Lordship. I was in also another court.
We have
Kindly
already
allow-
fixed the date.
Lordship, there is urgency. IA for bail is here, Lordship. He is in jail from last 8 months,
ঠিক
Lordship.
আছে, February, January, last week of did you? Putting it on last week of January.
Lordship.
Item number 15.
Yes, Mr. Ayachori.
So here in this case, Lordship, he was convicted under section 468 and 468 for Lordship 3 years, Lordship. And last occasion, Lordship, his previous bail was granted, Lordship.
Okay.
Till-
Now,
till
today is
Lordship-
for what?
Till today, Lordship.
Original case records
The-
have been received.
Lordship.
Learned Counsel. This is for what?
Lordship, IA is there, Lordship. His bail
Learned
there,
Ayachori is present on behalf of the applicant, appellant, and one other who has preferred the dismissal petition against the impugned judgment and order dated Iman passed in criminal appeal. Was friends affirming as yes, you have made under 468 and spans had to pay a fine or rupees. Second, we have does no formal notice. Meanwhile, call for the records of criminal appeal friends it is submitted to the original previous bound to remain on previous teacher next day. Okay. Who is the trial court judgment?
Lordship, in IA, Lordship, page 13, starts from page 13, Lordship.
Page
Page 13, Lordship.
13.
Lordship, page 13, start.
Trial court, trial court.
Trial court, Lordship. Appeal memo, revision petition, Lordship, page, starts from page 12, Lordship. And operating part, page 20, page 55, Lordship.
Birth certificate.
Birth certificate, Lordship. And some of the birth certificate were issued in the year 2002, Lordship. But NRC process was begun on 2015,
You have the power to issue birth certificate of any date.
Lordship.
Maybe.
Lordship. IA is pending, Lordship. That may be considered, Lordship.
Okay. Well conducted trial, 30 number of witnesses.
Lordship,
39.
39.
Exhibited 61 number of documents.
Lordship.
Court exhibit, material objects. You're a public servant or what? You're a son of Gaunbura.
Lordship,
Apart
son
from
of
that,
Gaunbura.
you are any,
No, Lordship.
hmm?
Initially, Lordship, allegation was against his father, Lordship, and after Lordship death of his father, he was. Subsequently, he was implicated, Lordship.
Yes, Mr. Sharma. I heard Mr. Ayub Chaudhary, learned counsel for the petitioner, applicant. Applicant as revision petitioner. And Mr. B. Sharma, learned additional public prosecutor for the opposite party, the respondent state of Assam. Full stop. The present application is preferred seeking suspension of the execution of sentence passed against the applicant, that's revision petitioner, and for his release on bail. Full stop. Para. The applicant as a revision petitioner has preferred the accompanying criminal revision petition, CRLREVP 495/2025. Full stop. Again, full stop. Against a judgment and order dated 6/11/2025 passed by the Court of Additional Sessions Judge Udalguri Appellate Court in criminal appeal number 01/2025. Post up. By the judgment and order dated 6/11/2025, the appellate court has dismissed the appeal preferred by the applicant revision petitioner and has affirmed a judgment and order dated 30/11/2024 passed by the Court of Additional Chief Judicial Magistrate Udalguri Trial Court in PR case number 1198/2017 within bracket ZR case number 715/2016. Full stop. By the judgment and order dated 30/11/2024, the trial court had convicted the applicant revision petitioner for the offense under section 468 Indian Penal Code IPC, and he was sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 20,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. Full stop. The appellate court has maintained the conviction and sentence passed by the trial court. Full stop. Para. It is the case of the petitioner that during the trial, the petitioner did not abuse with the liberty of bail granted to him and regularly appeared before the trial court. Full stop. Were you in custody sometime?
No, Lordship.
No.
Days, Lordship.
Hmm?
Page 13, Lordship.
Okay. During the course of investigation, the applicant revision petitioner was in custody for 60 days.
60 days.
Full stop. It is further submitted that the evidence are insufficient to bring home the charge under section 468 IPC, as there were number of gaps in the prosecution case and the petitioner in all possibility, applicant revision petition is in all possibility is likely to be acquitted, at least on the benefit of doubt. Full stop. Para. The power under section power of revision of this code under section 442. In exercise of the power of revision under 442, this court can, in its discretion, also exercise any of the powers conferred on a court of appeal by section 430 B and SS. Full stop. Having it is Om Prakash signing it would be perfect. Considering the fact that the petitioner, the applicant revision petitioner, has been sentenced to undergo imprisonment of 3 years, semicolon, he had spent 60 days in custody during the course of investigation, semicolon. And there is, and the projection made on behalf of the applicant, Caribbean petitioner, committee ordered that it is ordered that the execution of the sentence passed against the applicant revision petitioner shall remain suspended till the disposal of the accompanying criminal revision petition, and the applicant revision petition is allowed to be released on face bail
Lordship.
of 20,000 on surety to the satisfaction of the trial court
Trial court, Lordship. Additional Chief Judicial Magistrate. Muttalpur.
of additional chief judicial magistrate Swans.
Deeply obliged, Lordship.
Item 16.
May it please your lordship.
Get Talukdar crossing FIR.
Your lordship, if I may briefly narrate the facts.
1 minute. You are enjoying stay order. Is it not?
Yes.
Hmm?
Yeah.
Then we are awaiting service report.
Yes, your lordship.
Third, Miss
Miss Sidas, your lordship.
C. Das, Learned Counsel for the petition, Mr. B. Sharma, Learned Additional Public Prosecutor for the respondent, number 1, State of Assam, full stop. In view of the office note dated 30/12/2025, comma. I wait for the service report in respect of the respondent number 2, full stop. Lays the case on February 2nd week.
11.
The interim order past idea shall continue till the next report.
Item 17. Number 17.
Yes, Miss Sidas,
Lordship,
same,
arising out of the same FIR, your lordship.
same order.
Deeply your lordship.
Ah.
For hearing,
Oh.
items 20 and 21.
Only information.
Communication, but there were 3 queries, by the way.
Hmm. Second and third.
Third is nothing.
Huh?
First query was, what was the zonal valuation
Hmm.
fixed by the competent authority of government
Hmm.
for land during the period 2003-2008? The reply says, my lord, there is no record
Hmm.
of that period. However, 2011 it was 15 lakhs, in 2023 it was 16 lakhs.
2016 it is.
2023 is 15 lakhs per kattha.
Hmm.
And secondly, What is the policy of the government for
Hmm.
fixing the premium for settlement of town land? That details. And thirdly, is there any provision for fixation of premium at a lower rate than the Union Bank? They have given some evasive,
Evasive, too evasive.
I must admit.
The Revenue Department has a compilation, 3 compilations. I have to dig in my chamber. Right from 1960s, I have to dig in my chamber.
I have
2000, when it was settled,
It was
2008.
2008,
That is for what amount?
4,50,000.
4,50,000
Yes,
for a bigha. 1 bigha.
1 bigha,
1 bigha.
50,000 per katha.
1 bigha means 5 kathas. 5 kathas. If it is in, say, 2011, it will be 75 lakh value, government value, 2011. And you have been settled with what amount?
4,50,000.
4,50,000
This 30%.
in 2008. 2008. Two 2008. Three lakh. Land value is fixed at 3 lakh per quarter. 3 lakh is 15 lakh. 15 lakh means 30%. What is the policy? Huh? At whims or what?
30% of.
Depending on the person. Or what? There has to be a policy regarding fixation of premium. Any idea? Yes, Mr. Das, any idea?
On this matter, I have,
Fixation of premium.
this cannot be relaxed.
There has to be at least
Concern.
at par government value or maybe at lesser value. It is a prime area in the metropolitan.
But in the note sheet, I have seen, my lord, 30% of the.
For what? It cannot be at whims.
Why it has come to 30%, I think. That explains it.
What is due procedure and rules? Oh, land policy on sound. 2019. What is 3? What is the meaning of 3? ওইখন নহয় 89 খন চাওঁ 89 খন এই হেৰিত আছে গ্ৰীণ কিতাপখন আছে চাগে What is the meaning of this? There is any policy for fixation of premium for settlement at lower rate.
So my
Then-
specific query is that whether there is any procedure down the premium.
Huh? No, third line, the meaning of third line.
I don't get it.
Huh?
I don't get it.
No,
I
there
don't-
has to be yes or no.
Yes. There is any policy. Doesn't say any. There are no. Lordship, my third page was my letter.
That I have seen third.
Thirdly,
Hmm.
is there any provision for fixing the premium at lower rate in the job? And this is their requirement.
What is the meaning of that? Is there any policy for reduction of premium or not? That is the only query. Only query. It should be answered in yes or no. No means no. If yes, to what extent it can be reduced? But this is neither here nor there.
Whether there is a proper. Oh.
Better for 2 and 3 you should ask, because if that is according to the policy, it is all right. 30% of prime VGR or PGR? VGR land. At metropolitan area, you can reduce it for 30%. Good enough if there is policy. But this is not the answer. Is done with due procedure. Due procedure means there is existence of procedure and rules. Existence of rules. Is it not?
This thing to say. It is done.
That's
Following
There should be called here to explain. But they say anything and they get away. Say something.
In the basic query.
Let the officer come, he must be a high official. Let him explain. They say anything, but then they get away.
Answers to all the 3 queries were not given. Whether there is any zonal valuation, they escaped it. They avoided it. Then they said premium has been fixed as per procedure, due procedure and rules of the Assam Land and Revenue Regulation and Land Policy 2019. 2019 does not come. It should be Land Policy 1989, right? Then third, there is any policy for fixation of premium for settlement at lower rate than zonal valuation. That is neither no nor yes. Mr.
Explain, Lordship, I'll ask again, once again.
Now you put it in all affidavit.
And then.
I'll take it
whatever you said.
to a logical conclusion. You put it on affidavit.
Whatever, one good chance I'll ask.
One more chance and on affidavit. So that-
Consider the 14 to 22 case query, whether it was reserved or not. That answer has already.
That I will take care of from the records. There is
It has not been released.
that can be taken care of from the records. That I'm not decided, but so far as also premium is concerned and policy, that zonal valuation, if it is at a very lower rate also,
Okay.
4,50,000 1 bigha, then there should be tender. It would have fetched the government at least 1 crore. Right. And subsequent events are there, whatever may be.
Of course, there is other consideration. Because of Gandhi Smarak.
No, I have asked the question to Mr. Thor also that what philanthropic pursuits the needy had done earlier. He said none. Right? So,
Museum.
museum, but if it had any intention for multi-storied apartment building,
No, my lord,
that is a consideration.
that is not been acted upon. It was for
Acted
raising of
upon
fund-
is not
That was
issue.
probably for the raising of funds for construction of the Gandhi Sangrahalaya. But ultimately, that was not been done.
Otherwise, in criminal case, jurisprudence, there is preparation,
Exactly.
there is attempt,
Intention.
and there is accomplishment. We'll look into it, all these aspects. Mr. Taludar, you better get all the things clarified more in the form of an affidavit. Then we'll take, right? Because without a premium, without policy, without rule, without anything regarding premium aspect, because
Only one letter. that is-
situation may arise that he should, if the policy is there, it is at 100%, we may direct also to deposit the premium
Yes.
if the case is in your favor.
If there is no policy in that regard.
Then there has to be reason why it has been fixed at 4,50,000. Okay. Mr. Edhor, Learned Counsel for the petitioner, in WPC number 463, 2015, and for the respondent number 6 in WPC number 1236, 2017, and Mr. B.D. Das, Learned Senior Counsel listed by Mr. K. Kolita for the respondent number 4 and 5 in WPC number 463, 2015, and for the petitioners in WPC number 1236, 2017 are present. Full stop. Mr. B.J. Talukdar, Learned Senior Counsel, listed by Mr. P.K. Medhi, Learned State Counsel for the state respondents, is heard. Full stop. Mr. Talukdar has placed a communication bearing number so-and-so, dated 6/1/2025.
26.
25, huh? Okay, it's 26.
Signature here.
Come, I received from the Additional District Commissioner, Kamrup Metro District, Guwahati. Come, I address to him in reference to the queries, in deference to the queries made by this court on 2011-2025, full stop. As the response to the queries are found to be vague, Mr. Talukdar has sought another opportunity to seek clarification as regards the three queries and to bring the clarification by way of an affidavit. First off, it is observed that in the event the queries are not responded to in an appropriate manner, court may call for appearance of a responsible official from the revenue department at an appropriate time. Full stop. List the case or the letter being dated 6/1/2025. Supra is marked as document X and kept with the case record for further reference. Full stop. Lists the case on February 1st week. Cases.
It will be there.
Definitely.
First one.
First week. Or second week.
Second.
10 to
10 to
10 February.
Obliged.
Item 22.
Yes, Mr. Biswas.
This is a case of 2016, 306. He was convicted for 4 years. There are 10 witnesses.
You are on bail.
Yes,
You are on bail.
husband.
Bail.
Bail. There are 10 witnesses, but none could pinpoint this approximate cause of the I have done instigation to commit her suicide. But in fact, she was a married lady of a person at Mangalday, but husband died and she was facing trial. During that time, this petitioner from Telamara, appellant, got her married, they have brought her, they are living together, husband and wife, with the child from the first husband. The appellant was a auto driver. He was on the day of ill-fated incident, auto driver was out and she committed suicide. But on that day, some incident has taken place there.
Amicus is present. Okay.
On that day, some incident taken place. She has stolen one burner from a gas. Then she was caught.
Biswas.
Yes.
We'll hear it on some other day.
Obliged, madam.
Immediately after vacation.
Obliged, madam. I have got no objection.
306.
306.
So sentence is suspended, isn't it?
Suspended.
Then how many witnesses you say?
10.
10 witnesses. Okay. Any exhibit? Any
Nothing.
suicide note? No. And married for how many years?
2 years. Pardon? He.
Married.
Married for just 2 years she came.
And in the matrimonial house?
Yes.
Okay. No 304B.
Nothing of that sort, madam.
Okay.
Even, my lord, her body was recovered by army person. When child was weeping outside, the army people asked him what happened.
You were absent.
Yes. Husband was not there also. He was on the line of driving the auto. He returned and came to know that this incident.
S.C. Biswas. Appellant. MP Goswami. Learned Additional Public Prosecutor. Respondent 1, State of Assam, and Mr. T. Gogoi, Learned Counsel, Learned Amicus.
Yes.
For the appellant, respondent number 2. Who is respondent number 2? Informant.
Informant.
Okay.
Father of the
Okay. in respondent number 2, that's informant are present as sought for by the learned counsel for the party to lead the case on. Okay. Hearing 22nd January 2016, we'll hear it. Because of some other engagement, I am not taking up this matters today. 22nd.
Item number 24.
Any urgency? 24.
Since stay is operating, my lord, my complaint has been stored,
Right,
so I
right.
have urgency, my lord.
Right.
Of course, my lord failed in the morning, call me, take adjournment, my lord. So I pray, my lord,
Okay.
immediately after Bihu vacation, I'll fix it.
On a hearing date, it can be done.
No,
Yes, Miss.
F. Hussain, Lordship.
When do you want?
Any date, Your Lordship. After Bihu, Your Lordship.
3rd of February? 3rd of February. Okay. F. Hussain, petitioner. MP Goswami, respondent number 1, State of Assam. And Mr. Ziuddin,
Yes.
learned counsel for the respondent number 2, have sought for listing of the case on 23rd of February 2026. Release the case accordingly on so and so. The interim order passed earlier. Shall continue till the next date of listing.
Oblige, Your Lordship. Deeply oblige.
Item number 25. Items 25 and 26.
May I please your lordship? My lord, this is regarding non-payment of maintenance and for extension, my lord, of enhancement of my amount, my lord. First judgment was passed in 2018, my lord, by that CJM court. Then this reduced by session court, my lord, from 14,000 to 12,000. Then, my lord, both the side has come before your lordship. The husband also come. I am for the wife, my lord. That for they are for
Is there any scope for mediation? No.
my lord, perhaps not, my lord, because there are serious bitterness. Many cases are pending among them. My lord.
Okay, agree on a date. We are not hearing it today.
Today, my lord, not hearing, my lord. My lord, what happened, my lord? Only one small prayer.
No, we are not hearing it.
No, my lord, not on that, my lord.
Fix a date, agree on a date.
My lord, kindly a short date because
Agree on a date first.
my lord, after the just after opening the vacation, my lord, kindly, my lord, because around
After
14
the
lakh.
vacation, not after the vacation, 5th of February.
My lord, after my lord, what happened, my lord? The one child is reading in the school, my lord, and she's in the rented
5th
house,
of
my lord.
February, Mr. Talukdar, don't be unreasonable.
5th of February, my lord. My lord, it is up to your lordship, my lord, but the urgency is there, my lord, because non-payment, my lord. Number of times it is fixed for hearing, also ordered for my lord, early disposal, but could not be done, my lord, for last few years.
Okay, then we'll hear it now.
No, my lord, today, my lord, not today, my lord. Kindly.
If you so,
my lord, only,
so much urgency.
no, my lord, only
I'll
after,
avoid other
my
engagement.
lord, only after the vacation, my lord. I'm just only paying after vacation, my lord.
That is why I have said reasonably that 5th of February will be better or 3rd of February.
Finally, my lord, it may be, and my lord, may
Talukdar for the
may be made, my lord,
petitioner,
for disposal, my lord.
Mr. Talukdar, learned counsel for the petitioner. In 25, and for the respondent number 1 in 26, and Mr. A. Ahmed, learned counsel for the petitioner in 26, and respondent number 1 in 25 are present. No state counsel, I think.
No, that is
Mr. MP Goswami, learned additional public prosecutor for the state of Assam, is present. As agreed to by the learned counsel for the parties, list the cases on 5th of February for hearing.
My lord, the endeavor may be recorded kindly, my lord. I'm suffering.
Endeavor is always there. It is not that
the interim order is there.
only because of some difficulty.
In
Yes.
item 26, interim order.
Interim order, wherever passed, shall continue till the next date of listing.
Item 27. Number 27.
There is no representative on behalf of the petitioner today on call. Email petition. List the case. Later review, February 2nd week, no?
12. 12.
Hearing date. Oh, hearing date, 12. No conviction, like, what is the case about Mr. MP Goswami? Huh?
But some of the persons, my lord, from the foreign origin, man, they were apprehended, and against them, the case under Foreigners Act and Passport Act has been registered, my lord. Therefore, investigation is going on, my lord, and they have come for as criminal petition for causing of that FIR. man.
What is the stage of investigation? Can
It
you
is my, yes, ma'am.
still?
Because on the last occasion, ma'am, we tried to contact, so they have sent a CD. ma'am.
CD?
Yes. ma'am. So perhaps, ma'am, continuing. ma'am.
What is the progress of investigation?
Progress, ma'am, I have not checked, ma'am. The CD is there, ma'am.
You check, get the status.
Plus.
And it is quashing.
Quashing, ma'am.
So whether privacy case is there or not, please
Yeah,
apply
yeah.
this code. Okay. MP Goswami, Land Tradition Public Prosecutor, has submitted that he has received the case. It is up to date or what?
Yes, it is up to, ma'am, 1524. 1 year back.
1.5 years.
1.5 year back.
And who has received the case diary? Has submitted that the case diary has entries up to 1/4.
And also we have 1/5/2024.
1/5/2024.
And we have received
And
it on
we'll make endeavor
7/5
to obtain.
We will update the CD, ma'am, because
He will place an up-to-date case diary on the next date of listing.
Yes.
Item 28.
Yes, what is this case about?
May I please, Lordship? Lordship, here the two appellants are there, my lord, and they have been convicted under section 306 and 34 IPC, my lord.
306.
Yes,
For
my
how
lord.
many years?
For 7 years, my lord, and a fine of rupees 10,000. In default, my lord, 6 months. Applicant number 1 is, my lord, applicant number 1 is the father-in-law, and applicant number 2 is the husband, my lord. And then they are since behind the bar for 18/4/2024, my lord.
Conviction is 7 years.
7 years, my lord.
18/4.
18/4/2024, my lord. They are behind the
18/4/2024.
Yes, my lord. Judgment date.
1.5 years.
No, no, yes. I have yes. I list is. Woman, I am praying for.
3rd of February. 3rd of
Yeah, my lord, I am praying for bail.
3rd of February. Appellant. You are Mr.
Yeah, how are you, my lord?
A. Hari for the appellants. MP Goswami, Land Additional Public Prosecutor for the respondent states. Somebody else is there also.
Yes, response number 2 is there, ma'am.
But
Purpose
it
is
is a state
Yes.
prosecution.
State position. Yes, ma'am. Not
required. List
Yes.
the appeal on
There is also
3rd of
there is
February.
judgment of the our High Court division bench, my lord. That is not required, ma'am.
Not required.
Yes.
Services already
I'll
completed.
submit.
3rd of February.
Item numbers 29 and 30.
Oh, Mr. Taludar. Yes.
My lord, sorry, my lord, this is some urgency, my lord. My lord, parole, my lord, mother, my lord, expired, and only son, my lord, for last rites, my lord. He is convicted for under section 326, my lord. My lord, for 8 years, my lord. So, my lord, in main case is admitted, my lord. Main appeal is admitted, bail was rejected, my lord.
Bail was rejected.
Yes, my lord, bail petition was rejected, my lord.
Conviction and sentence?
Sentence was 8 years, my lord.
8 years.
8 years under section 326. There are many accused, my lord, including 302. So there are many appeals are pending, and I am convicted for under section 326.
It's the same.
Case same, but appeal is different. Appeal is different because some are single bench, some are double bench. That's why, my lord. Initially, it was filed together, but by the after observation of the learned bench, my lord, it was again refiled and individually filed because
So he individually filed.
my lord, those who are below 10 years, my lord, single bench, my lord, and those who are above 10 years for life, my lord, they are for 14 years, my lord, division bench. So initially it was filed together. That's why, my lord, thereafter it was filed separately, my lord. And the criminal appeal number, mine one is, my lord, 168, my lord, 25, later on filed. It was also admitted. I have annexed the orders, my lord.
By which order it has been separated?
My lord, not
Oh,
my lord,
okay.
observation, after observation being made, my lord, it was separately filed again.
Where is the
My lord, page kindly turn to page, my lord, 25, my lord.
of which case?
Oh, my this IA, my lord, 1359, this instant IA, my lord. Page 25, my lord. Then, my lord, page 26, my lord, top paragraph, my lord, relevant part.
Is 20?
6, man. My lord, after going through the memorandum of appeal, we
Okay.
find that the different appellants have been convicted under different provisions of the IPC and their sentence also vary from one another.
CRPC. Where is the judgment in the appeal?
Yes, my lord, day 133 regarding the sentence, my lord. Page number.
The forum of appeal is dependent on the trial court or dependent on the sentence?
Sentence. my lord.
Sentence, my lord.
Huh?
It has to be on the my lord, sentence, my lord. Because because as per the my lord, if it is more than 10 years, my lord,
That is
then
High Court rules.
it rules, my lord, as per
That is High Court rules.
rules.
High Court rules cannot be above
No,
CRPC.
No, my lord.
I don't think High Court rules will be above CRPC.
No, my lord.
What is the sentence?
Sentence 8 years, my lord, and 5 years, my lord.
8 years.
My lord, the relevant part is, my lord.
How can it be single judge?
No.
Read BNSS
Yes.
now, 415. There are 3 parts to it. That observation at page 26
My lord.
is something about composite appeal. Court has tentative observation. Court has not said that it is before single judge. Has it said so?
Not clearly.
Not clear. Now, do we have the CRPC or BNSS?
No.
This is my perhaps
This
the
CRPC.
BNSS, BNSS.
Perhaps CRPC, the
Yeah.
case of earlier, my lord.
16.
415. Do you have the CRPC or BNSS? Eta copy or extra আছে নেকি BNSS?
BNSS.
দুটা copy নাই. আমার দুটা copy নাই.
My lord, your lordship is read, my lord. So,
3 parts.
my friend has, my lord.
You read. Yes, Mr.
My lord,
Goswami, you read
415, my lord, postponement of
subsection 2.
Yes, my lord.
415.
415, my lord, yes, my lord. That is postponement of execution of sentence of death in.
No, you are reading 430, 415.
415, I am reading, my lord.
BNSS.
Oh, my lord, CRPC.
This is in which year?
My lord, it is.
It is 2016,
My lord,
CRPC.
CRPC.
No. This is a procedural law, sir. This is a criminal level of 2025.
Yes. Criminal level of 25 and 20, yes.
Right.
24. my lord.
By that time, BNS has come. This is
Yes, sir.
procedural law.
No.
Now read 415. Let us understand.
Yes, yes, madam.
My lord, occurrence of
Any-
earlier date, whether it will be by BNS or no.
Any person convicted on a trial held by a high court in its extraordinary original criminal.
What you are reading? 415.
415. 415. Appeals from.
Subsection 2. Subsection 2.
Yes, ma'am. One also I read. Number
That
2.
is, subsection 1 is High Court trial.
High Court trial, ma'am. Now, 4152 regarding session, ma'am.
Three
Any
parts.
person convicted on a trial.
Trial.
con-
Held by a
by
session judge. Right. This is 1.
One.
Next.
Or an additional session judge.
This is second.
Second, madam.
Third. Or.
On a trial.
Again on a trial.
On a.
Right.
Yes, madam. Held by any other.
On a trial is repeated.
Yes, yes. On
Held by.
Held by any other court.
Court.
In which a sentence of imprisonment for more than 7 years
Has been passed.
against him or against any other person convicted on the same trial,
Comma. May appeal to the High Court.
Court.
So,
Ma'am.
in my view,
Yes.
if it is a trial
Yes.
by the session judge
Yes.
or additional session judge,
Yes.
then the appeal is to be before the High Court.
High Court.
Right.
Yes.
Now, second part on a
Mm.
trial below 7 years, it is
Mm.
before another court.
Before another.
Right.
Right.
So
Yes.
that is session judge.
Yes. Yes.
If it is above 7 years, then it is to the High Court.
For more than
Right.
7 years, it is in the High Court.
So obviously it is before the High Court.
High Court.
Now,
Yes.
the question is in a same trial.
No.
Next question is in a same trial,
Same case.
different sentence have been passed.
Passed.
Now, if it is a trial where many accused persons are there,
There.
and because of some are convicted under section 302,
Yes.
some may be under 326.
Yes.
Now, when an appeal is preferred,
Yes.
according to High Court rules, if it is less than
Less.
10 years,
Yes.
single judge,
Yes.
more than 10 years before the
I've understood what. Yes.
Division.
division bench.
Mm.
If that is strictly followed,
Yes.
in a trial where there are more than one accused,
Yes.
different sentences are passed.
Yes.
If any finding is given
Yes, ma'am.
by the division bench,
Yes.
whether that will be binding for a single bench,
Yes.
if different appeals are preferred,
Yes.
or discard
Yes.
the finding. I am on my own.
Mm.
Just a question for
Yes.
me. This has arisen in my mind,
Yes.
so I have asked you.
Yes.
Now, where is the High Court rules?
My lord, probably, my lord, it has to be in a division bench, ma'am.
That is what my
But-
feeling is.
Yes, because your lordships is very correct, my lord. If
It
my lord,
says only that after going through the memo, we find that different appellants have been convicted under different provisions of the IPC and their sentences all vary from one another.
Yeah.
Notwithstanding the same, a composite appeal has been filed by all the appellants, although it is doubtful as to whether the appeal can be taken up by the division bench with regard to conviction of all the appellants.
No.
It has expressed a tentative view.
Tentative.
Whether it is correct or not,
My lord.
I have some doubt.
On that one argument took place there also, my lord.
I have some doubt. No, it has not made any.
Conclusive. Nothing conclusive. my lord.
See, if the law is settled, and if this appeal is decided by a single bench, and later on it is found that this court has no jurisdiction, the judgment will be nullity.
knowledge.
No jurisdiction, any judgment is nullity.
Knowledge.
And suppose I allow,
My lord.
on the same set of evidence,
Lost.
whereas
Yes.
the division bench dismisses.
No.
What will happen?
My lord, different acquisition may be taken by different.
And
on the
for
same
criminal,
evidence.
for criminal, if criminal jurisdiction,
Hmm.
any judgment given by a single bench, no appeal lies to the division bench
No.
to rectify.
Rectify.
These are small issues, but
But
it
very,
has relevance.
very critical.
It has relevance.
Really best.
Because if I have no jurisdiction, my judgment will be nullity.
That's my
Have
lord.
you understood?
Yes, this is my lord.
I may be wrong. I'm not saying that, but these are the doubts which has arisen in my mind. Criminal appeal, 1 minute. I do not want to be.
My lord, I'm also not sure, my lord, whether CRPC will rule or BNSS will rule. I don't know, my lord, because case of 2013 or
Whether it
16.
is CRPC or BNS,
But
415 is same.
Same. Exactly same.
Exactly same.
Well,
and logic same. My lord.
Logic is same.
exactly same.
Because why I am saying so,
Yes, my lord.
after hearing you, if I find that I have no authority,
Yeah.
then I'll.
Not only that, my lord, there is very much crucial logic, but if both two courts appreciates evidence in a different way and gives different findings, my lord, it will conflicting. It is also a logical issue.
No, if I, and for that matter, after 2 years, your appeal is hard.
Yes.
My lord.
And thereafter reaches a conclusion that this court
No.
cannot hear this appeal.
Yes.
You will lose
Yes.
2 years.
Yes.
Have you understood?
Yes.
Criminal appeal part 2 court আছে. High Court rules criminal appeal. Any notification is there? Your notification আছে নাকি? Huh? Criminal appeal. Preparation of paper book, appeal to the 78, it was Supreme Court. $78 no. Okay, 122. 122.
This is month to month. Okay.
14 years. Life.
This is actually 20. If I like 6 and কোন এসেছে সোরাপালি এনভাইসিং বাকি আনোয়ার হোসেন কিছু conviction
Take policy because documents are
না conviction কি না
it will life. It will have 6 years. Yes, 8 years. 5 years. They were acquitted. Once.
because there's
Only 8 years.
মানে এখানে এটা আছে
এই আমার এই বললে তোর কোনটা এখানে কাপড় আছে তো এখন এই হেলিংলি কিতাপখন যে বনাইছে যে এই যে তোমাৰ সমানি তখন কিতাপখন আছে ওপৰতে আছে
Another single bench also admitted this one again, my lord. Page 28, my lord. Page 20.
because another suppose Mr. Talukdar has been acquitted.
Acquitted.
Then appeal will lie before the division bench.
Division bench. No,
Because
no,
if charges has been framed under section 302
Lords.
or section 326 is tribal by whom?
326 tribal by my lord, here.
Session judge.
Session judgment.
And maximum punishment may be more than 10 also.
More than 10 also.
If he is acquitted.
But not
He's
division
a-
bench.
Huh?
Not division bench, perhaps.
No. Then in that case, appeal will be under section 372 before the division bench.
Division bench. Okay.
Oh, my lord.
Yes. And another thing, my lord, in other way around, my lord, if my lord, the conviction has to be enhanced, my lord. In that case also there will be a problem because my lord, if the single bench, there is a single bench, he cannot enhance the, my lord. Suppose, my lord, after appreciating the evidence, my lord, is found under 302, my lord.
Then has to be remanded.
Then has to be again, or it can enhance, the High Court has the power to enhance also.
This is a
But-
hunch which I am having that something is not falling into places.
Yes, Lordship can, just one provision, my lord, the CRPC 377, my lord, subsection 3, my lord. The Lordship is
370 CRPC.
377, my lord.
Okay.
Subsection 3, my lord. When an appeal has been filed against the sentence on the grounds of his inadequacy, a court of session or the case may be the High Court shall not enhance the sentence except after giving to the accused a reasonable opportunity of showing cause against such enhancement. And while showing cause, the accused may plead for his acquittal or a reduction of sentence.
One question will be there also. Let me see. 224. Where is the 10-year where is the 10-year part? Notification from Kota Seva.
Notification.
Ekhone, no? Ekhone it was nine. That is not clear. This notification is not clear. That number of accused persons
When, my lord?
facing the same trial are sentenced differently than or like I said, because I have read somewhere. Some Supreme Court judgment I have read somewhere.
Yes.
For the purpose of continuity, consistency,
Yes.
it has to be
Before Higher Court.
before the same court.
Same court.
And if one of the persons is convicted and his appeal is to be heard, what is 386? Let us see.
Is
Mm.
29.
Oh,
It wasn't the do.
that time we should.
Issue is going.
Yes.
Ah,
Yes. Mm. Bikram Nath, one is there. Oh no, man. It's three husbands. There is three husbands. Mm. This 2021, madam, SCC online, SC 1017.
2000.
2021, SCC online, SC 1017. SC 1017.
Yes, Mr. Soma, what do you say?
It is find out.
What is your thinking process says?
I'm following. There, no?
I said,
Print up to guys. What are you saying?
Pulaman. Oh,
Because even.
that same code is in bold, right?
The same code is in bold.
And there is some sign like this. If you put this, then you will get the citation.
Well,
That is what you said.
Yeah.
2021.
2021, no,
There is a sign. There is a sign like this.
No.
Is it not?
It is, I have, in a separate matter, I have found my.
Because for the purpose of consistency
Well,
in
yes.
appreciation of the evidence,
That is
same set of evidence,
same set of
because witnesses are same.
same man.
If X and Y, PWX,
Yes.
he says something.
Yes.
If division bench says interpreted in a different manner, single bench interpreted in a different manner,
Contradicting
Yes.
each other, my lord.
Yes.
then
Interpreted.
it will be, because
Yes.
the line it says, definitely it is after research.
No.
It says, if in a trial involving multiple accused,
Yes.
any one person receives a sentence exceeding 7 years, all other convicted individuals from the same trial may also appeal to the High Court even if their sentences are shorter. Okay.
No.
In a sessions trial with multiple accused, if different sentences are awarded, all appeals typically lie before the same court, regardless of the individual terms of the sentence.
Sentence.
Same court is High Court,
Yes.
but still there are two courts,
Two courts. yeah.
single,
Within the High
And-
Court.
within the High Court, single bench and division bench.
Division bench. Lordship.
And ultimately for the purpose of consistency
Consistent.
and same yardstick,
Yeah.
this logically,
Yes,
as on that, I am
Yes.
logically,
Lordship.
that same court should
Yeah.
hear,
Same.
yes, different appeals.
Lordship.
I don't know for what reason this has been done, but this can be possible. Because of easier appreciation, this might have observed, but this line that whether doubtful as to whether the appeal can be taken up by the division bench with regard to conviction of all the appellants. That part I have some doubt whether that is correct or not.
It is not clear at that point of time. That is why.
But there is no
bit of-
notification as on that.
Yes.
I'll ask the registrar also.
Lordship.
Palani, 2021. Find out.
I will
if
find.
It is day after tomorrow.
Lordship.
You find out
Yes.
because this is a question
Yeah, that-
which goes to the root of the matter ultimately. What do you say?
My lord, as lordship mentioned, that is the conviction is 7 years, my lord. And there is the jurisdiction of single court. But here, my lord, is a more than 10 years. Is a division bench and
One under severe punishment, two of the accused have been
Life.
Life.
Yeah,
It is
here,
a
here,
life.
my lord. But
Huh.
as a lordship read, my lord,
No, that is a
there is
different
7 years.
issue.
Yes, yes.
Different.
But in the same
Same
trial,
trial.
Same time.
different, and what was the charge framed against you?
My lord, I have not gone through today, my lord.
Huh?
Parole.
Start, let
There is a
we'll see from the judgment, man.
For
It will be in a judgment.
It will be in a judgment.
Charge sheet, all are under section 302,
And
307.
my lord, yes, ma'am. 324, 326, 307, 302, 149. Against all
All
accused.
302 also framed against you.
All against
149, 307.
all accused.
Charges were framed. However, conviction was because of lack of evidence under 149, perhaps
Yes.
you have been awarded 326.
My lord, because Lord, the main deceased was admittedly
Because,
got hit by me.
not because that, because 4 persons were not, 5 persons were not found involved.
Yes.
It went down to 4.
Yes, 3 were acquitted.
By that 149 gone.
My lord.
149 gone.
3
Right.
3 were acquitted also.
Unlawful assembly, yes.
Yes.
So 3 were acquitted. Remain 4. 149 requires 5.
5.
149 gone. Otherwise, you could have been under 302.
Come under 302. Throw 149. Throw 149.
Right.
That is why they were left. Otherwise,
That is why 4 persons have been. If 5 are involved, he would have been under 302. Along with the other 2.
Maybe, yes.
Alright, that is another reason.
Yes.
Without looking into that, I can understand 4 have been charged. Okay. A.K. Talukdar, appellant, MP Goswami, release the case on Thursday.
Yes.
We'll find out.
Lordship.
Fine.
But please make research.
Yes, sure.
Mr. Goswami,
Lordship.
homework.
Homework. Lordship. Lordship.
I'll also look into it.
Yes.